Over the years, proponents of firearm and drug prohibition have mostly fallen along ideological lines, but a recent Supreme Court case where these two policy areas intersect may buck this trend. In United States v. Hemani, justices are weighing in on whether the federal government can ban people who use controlled substances from owning firearms under the Second Amendment. First, some backstory. Before his arrest in 2023, Mr. Hemani was the subject of a multi-year FBI investigation for terrorism-related activities. While searching his house, they found a gun and a controlled substance. In the end, the FBI did not produce evidence of terrorism. Instead, they charged Mr. Hemani with possession of a firearm by an unlawful user of a controlled substance. The substance? Marijuana. SCOTUS heard oral arguments at the end of February, during which the justices confronted deeply entrenched views about public safety, personal liberty, and who is afforded legal protection of their constitutional rights. The justices questioning during that hearing made clear that Hemani is not about a single amendment, defendant, or statute, and may potentially force a reckoning over how constitutional rights are defined and constrained when long-standing prohibitions collide. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we're unpacking amici briefs and arguments from the Supreme Court case, United States v. Hemani. If you like what you hear in today's episode, visit go.osu.edu/drugsonthedocket to follow the series. All right. So today it's all about drugs and guns, specifically the U.S. Supreme Court case United States versus Hemani. In this Supreme Court case, SCOTUS is considering whether this federal law that bans illegal controlled substance users from possessing a firearm is consistent with the Constitution's protection of gun rights under the Second Amendment. We have not one, but two Pepperdine professors here to help us better understand this case and what it could mean for gun laws nationwide, especially as they intersect with prohibitions on gun possession by drug users or even those with drug addictions. With that, Doug, the floor is yours.
Thank you, Hannah. I am so excited that we're joined today by two associate professors from the Pepperdine University Caruso School of Law. That's Joel Johnson and Jake Charles. Joel is a scholar and teacher of criminal law and procedure, statutory interpretation, and constitutional law. His articles have been published in leading law reviews. Multiple federal courts have cited his work, and he's been quoted in major news outlets such as the New York Times, Bloomberg Law, NBC News, and on SCOTUS blog. He's filed an amicus brief in Hemani that gave special attention to issues of statutory interpretation. Welcome to the podcast, Joel.
Thanks for having me. It's a pleasure to be here with you, Doug, and Hannah, and also with Jake. I talk to Jake a lot, but I'm always happy to talk about Hemani with Jake.
I imagine that's true because Jake, as I understand it, is just down the hall from you, at least most of the time. And Jake is a constitutional law scholar who focuses particularly on the Second Amendment and frequently comments on legal issues surrounding firearm law and politics. Jake's writings have appeared also in major news outlets, leading law reviews, has been cited in numerous court decisions across the country. He joined Pepperdine Law after serving as the inaugural executive director of the Center for Firearms Law at Duke University School of Law, where he remains an affiliated scholar, and he previously served as chair of the section on firearms of the American Association of Law Schools. It's no surprise with all this expertise that Jake also was involved in an amicus brief for United States versus Hemani. Thank you for also joining us, Jake.
Thanks for having me. Excited to be here.
I love the idea of you guys being just down the hall from each other.
We literally share a wall.
You share a wall. That's amazing. Well, Hemani has become such a flashpoint for gun law, drug law, and constitutional interpretation kind of all at once. It's like this perfect storm. Luckily, there's a lot of applicable expertise between the two of you, and I really do hope that you'll, demystify some of these topics or help us understand the complexity since they intersect so much. I remember preparing for this episode, I kept an eye on incoming amici and noticed when Joel filed his brief because it seemed different from a lot of the previously filed amici, and your take really focused on statutory interpretation rather than on the Second Amendment. Is that like a fair characterization?
Yes, that's That's totally accurate.
So, you argue that this case can be resolved without deciding a major Second Amendment question. So tell us about why you decided to go the statutory route.
Yes, I'm happy to do that. There's a lot of energy right now among litigants and particularly criminal defendants, right, who are looking for ways to challenge almost every federal gun law on a Second Amendment ground. So as naturally, this case is sort of teed up as a Second Amendment case, like you said. But it's my view, you can't decide if a law violates the Constitution until you actually know exactly what it covers. And so in this case, the big problem, as I see it, is that the phrase unlawful user in the statute is inherently vague.
There's this notion of regular user or habitual user that they've already tried to address by rewriting the statute. And is it fair for me to say that that should be Congress's responsibility and not the role of either the executive branch through prosecutorial gloss or even to some degree the courts to try to fix up what I share your view is an open-ended term?
The Solicitor General is pushing this gloss of habitual user. And you're right that that's been argued in lower courts too. And I don't know the exact genesis, but I think it has to do with the fact that certain circuits over decades have adopted something like a habitual user construction of the term, right? Because it's not defined by the statute. But yeah, it seems to be, though the government's not totally clear on this, something like marijuana use every few days or a couple times a week or something, or at least that's what's present in this case. In my brief, I argue that there's a line drawing problem here. And the question is, who gets to draw the line? Do we say Congress needs to be clear on drawing the line? And if it's not, we will sort of err in favor of the criminal defendant, which would be a narrow reading of the term. Or do we say prosecutors essentially get to be delegated the task of drawing the line in the way that they think is most beneficial, which tends to be broadly?
And did you get any sense from oral argument that any of the justices were keen on embracing this, I think you've called it as an off-ramp to avoid some of the Second Amendment work?
Justice Gorsuch had a line of questioning that sort of went right to the heart of the unlawful user definition in the statute. And he pointed out, actually, that the government hasn't been consistent in how it's defined unlawful user in different contexts and over the years. So I pointed this out in my brief, too. For decades, there was this long-standing regulation that actually took the position that if there's proof that someone used even just once a controlled substance unlawfully within the last year, they're an unlawful user under the statute. But now, of course, as we just discussed, the Solicitor General is saying it has to be habitual use. And so even the government hasn't had a consistent theory here. And then Justice Sotomayor also seems like someone who may be inclined to go in the direction of my brief. She also noted this concept of habitual user is actually used in one of the relevant statutes, but it's used to define the term addict, not unlawful user, which would suggest that maybe unlawful user should mean something different than habitual user, which cuts against the government. And then finally, Justice Barrett and Justice Kavanaugh, they seemed focused in different ways on how to parse the statute. And so that maybe means they're thinking they need to determine what the statute means.
I believe Justice Kavanaugh brought up the issue of mens rea, which is, of course, what a defendant needs to know in order to be liable under whatever statute we're talking about. And there are other interpretations of this general gun control statute that says the defendant needs to know they're one of these prohibited categories. It would seem that you would not only need to have a clear definition of unlawful user, but clear enough that the defendant would know that they fit into that category, however defined. And that's just, that's a lot.
Yeah, no, I think that's exactly right. How is someone supposed to know whether they count as a habitual user or not?
Jake, you also filed an amicus brief, but instead of focusing on statutory interpretation, your brief seems to reflect that this case does, in fact, pose a Second Amendment question. So what was your main argument?
We focused on the Second Amendment issue because we are Second Amendment scholars and the courts granted the question, presumably to decide the Second Amendment issue. We are kind of taking it as, assume the government's position on the construction of the statute is correct and it doesn't create these vagueness concerns. Now, what should the court do if it actually gets to the Second Amendment question? And so our argument is essentially twofold. One, that historical tradition supports the notion that legislatures are entitled to make categorical determinations about people who cannot possess firearms. The Second Amendment doesn't require individualized determinations of danger. The second point is that those legislative determinations are entitled to some form of judicial respect. The historical record suggests, and modern courts can do review by looking if there's evidence to support whether particular categories of people are in fact more dangerous with firearms. And if the evidentiary link is missing, then perhaps the law is unconstitutional in that particular setting. The government's defending the law in this case, but the government, as you know, this particular administration wants to tout its bona fides as strong Second Amendment supporters. And so there's some awkwardness with defending a law against a Second Amendment challenge. And so the government's position to us is unduly narrow. The government's position is essentially that legislative determinations of particular categories of people have to match a historical category of people. And in this case, they point to habitual drunkards. Our position is the government can make these categorical determinations based on the principle from history that people who are dangerous with firearms can be disarmed. So you don't have to find an analog to a particular group today, like drug users being similar to habitual drunkards of 1791. Instead, it's the people that are dangerous today with guns can be disarmed because they fit the historical tradition of people who are dangerous with guns. So that's what the kind of the key arguments of our brief are, and then kind of how they are a little bit distinct from the government's arguments.
Wonderful. Thank you so much for that. And I want to unpack both parts. One is the categorical approach you're defending go beyond dangerousness, or is it just one huge big category of dangerousness? And as long as the government is articulating its claim that its regulation is based in concerns about danger, then we're check on category and we move on to the evidence piece of it?
I don't want to speak for all of my co-authors on the brief, but the brief focuses on the dangerousness strand of historical tradition. There are other potential strands of historical tradition that might support categorical people-based disarmament. One might be a law-abidingness rationale. There's another strand that's disarming people who are outside the political community. But our brief is just focusing on the dangerousness tradition. What we see in the historical tradition is, yes, Congress or the legislature makes that determination. Once they make that determination, this group we deem to be dangerous with respect to their use or misuse of firearms. That's the categorical determination. That's consistent with historical principle. And then a court would test that by determining whether or not the judgment that this group is dangerous is actually grounded in something beyond legislatures say so.
So how does this deference work exactly? I am certain there are a range of assertions that would be made by different types of advocates for and against different types of drugs, or I'll even just call them substances, right? So that presumably caffeine makes people jittery, tobacco has its own set of effects. Those are legal drugs currently, but certainly ones that I could imagine a legislature suggesting creates a risk of dangerousness for firearm users, alcohol being the most obvious example that courses through the conversation here. Would this require every type of drug user to assert, well, the drug that may not be legal but doesn't make me dangerous is one that can't disqualify me from gun possession, because if dangerousness is really the touchstone, absent a government showing that this category of drug makes me categorically dangerous, I should retain my gun rights.
Yeah, so maybe I'll step out of amicus author role. Hemani's argument about the as-applied nature of the challenge. And so when we talk about as-applied challenges, we're talking about someone's claim that the law can't be constitutionally applied to them, as distinguished from a facial claim that says the statute is invalid in every context. And so Hemani's raising an as-applied challenge. And one question is kind of how broad is that as-applied challenge? Is it as applied to actually Mr. Hemani himself? And so the government would have to show that his use of drugs made him dangerous with firearms. Or is it maybe one step higher? Is it that an as-applied challenge to marijuana users generally, or maybe marijuana users who use it a couple times a week? Are they particularly dangerous with firearms? Maybe going up another level, is it Schedule I drug users, or is it particular categories of drugs? I think all of those questions are really unclear. The most that I think that I would be confident saying that I think historical tradition rejects is the notion that categorical judgments are impermissible. And so some kind of categorical judgments are okay. Whether that is a drug by drug categorical determination or a schedule by schedule categorical determination, I don't have a particular view on. I just think that every single marijuana user, let's say, wouldn't be entitled to come into court and say, show that my particular drug use with firearms makes me more dangerous than others.
I thought it was fascinating that Justice Barrett was very focused on the unlawful use of Adderall by a spouse taking their spouse's prescription. And I thought it was interesting across two dimensions. One, Hemani is not an Adderall user. He's a marijuana user. But I also thought he might be trying to get to the idea that clearly there are some, modest uses of unlawful nature that aren't dangerous at all, like using somebody's Adderall. But would it have to be a showing in a court case that would enable a comfort level with what Congress has decided is illegal use? Or would it need to be sort of findings by Congress or, some legislative determinations that's the basis for being comfortable that the categorical dangerousness requirement was satisfied?
The concern, I think, was both about can the principle really extend that far, and about had Congress actually made a judgment that these people are dangerous, no matter which of the drugs they might be ingesting. And I think that concern was echoed by not just Justice Barrett, but Justice Sotomayor, by Justice Kagan, to some extent, some of the other justices. To bring it back to my brief a little bit, our argument that Congress can make categorical judgments, I think I heard a majority of justices agree with that notion. But with respect to whether Congress had done so here, I think there might not be a majority of justices who think that Congress had actually made that determination with respect to every drug that had been scheduled. Now, it could avoid addressing that question by just focusing on marijuana and say maybe Congress had made that determination with respect to marijuana or not. But there was a real reluctance, I think, to say just by virtue of classifying a drug under the Controlled Substance Act, that somehow had indicated Congress's judgment that that person would be dangerous with firearms. Justice Kagan said, isn't the scheduling motivated by a whole bunch of different concerns than what someone's going to do when they have a firearm or whether even someone's going to be dangerous? Justice Alito, though, said, isn't the fact that in the Gun Control Act, when Congress said we're prohibiting people from possessing guns if they are unlawful users or addicted to things in the Controlled Substances Act, isn't that their determination that those people would be dangerous? Some of the, I think, confusion here is the new nature of Bruin's test requiring a historical analogy, because in 1968, when this law was enacted, Congress was not thinking that it had to point to a specific historical tradition to justify its gun laws. So if it was doing it today, maybe it would make those findings. Since it didn't do that at the time, does that mean the findings are necessarily called into doubt? I think the court's kind of grappling with that question.
All these questions from various justices about the different drugs on the controlled substances list. I took these questions as being concerned about sort of administrability of some test that's announced. And so what came to mind for me is sort of when you go down this dangerousness path, potentially as sort of drawing a line between what drugs could be included, what or not, it sort of sounds a lot like the Armed Career Criminal Act, which increases penalties on the back end for certain convictions if there's 3 earlier convictions of a certain type. And that has caused just a lot of consternation in the courts where you have to go offense by offense to determine as a categorical matter whether any particular crime is a crime of violence. And I could just sort of almost feel the justices' concern that they could potentially open up a Pandora's box where you have to go drug by drug to determine whether it's sufficiently dangerous or something.
I think that's a great point, especially as we think about marijuana. I found it interesting that marijuana got relatively little attention in the conversation throughout the oral argument, especially given that's the drug that Hemani is accused of being involved with, I guess, habitually while possessing a firearm. And I'm wondering, is there anything marijuana specific about either your argument or your sense of how the court feels it needs to address this? The point that Hannah made at the outset that I think is why this case is so broadly watched beyond the Second Amendment concerns that many in the gun control and gun advocacy community focus on is, we're talking about a drug that has been legalized in a variety of forms in most of the nation. Data suggests there's somewhere between 20 million to maybe 50 million, at least part-time users, maybe regular users, probably not habitual users, but certainly unlawful users under federal law. And, maybe a third of residences have a gun around. And so we might be talking about literally millions upon millions of people who will be deemed potential felons if there's not some success with Hemani's arguments, even though that's not how the law is often enforced. I would both be interested in your take on why there wasn't more marijuana-related talk during the oral argument and whether the real politic of this behind the scenes might be influencing the justices.
You're absolutely correct that the focus of argument was not on sort of marijuana specifically, although I think one way it did come up a couple times, which is related to all this, is this notion that it may be rescheduled from Schedule 1 to Schedule 3. What that would sort of indicate is that there's been a finding that it has a lower potential for abuse than the drugs on Schedule 1, like heroin or cocaine, maybe less safety risk. And so I think that fact could be a real background factor here, especially because the government sort of pivoted to this backup position a couple times in argument where they said, well, maybe the statute would only constitutionally be applied to Schedule 1 and 2, but not 3 and 4. If marijuana were rescheduled, then suddenly, maybe not in this case, but in a future case, it would fall out of the scope of what could be prosecuted under the statute. And I'll just say on the broader point about state laws, if either my statutory route or Hemani's lead Second Amendment argument, if that prevails, I actually do think that would sort of bring in line a little bit better the federal sort of scheme with the state schemes, because then it would be more of a conduct-based prohibition where you have to be actively intoxicated while possessing a gun to be prosecuted. And that seems less of a problem in terms of mixing with the state legalization efforts.
As I'm listening to this, I'm thinking about the fact that categorical could be by schedule or by substance. And so if it's by substance, it could be any schedule. But if it's by schedule, then any substance within that schedule, it would have to apply across the board. So it makes sense when I'm hearing there are some drugs that are Schedule 1 that you wouldn't necessarily affiliate with someone whose conduct is violent. But then I think about how with marijuana, police can use their discretion to search someone. And so therefore, you wouldn't necessarily want to exclude marijuana from something like this because that really disarms police or even prosecutors from having leverage in certain cases. Like, is that a far off take in all of this?
You're sort of talking my language now. When I teach criminal procedure, I point this out to my students. I think the main reason marijuana is still certainly on Schedule 1, but I think sort of has the focus of federal regulation is to give police officers the ability to engage with individuals on the street, right? Whether that's a stop and frisk or a search of a vehicle, it's a great tool, and it happens to have a very strong scent, right, that allows for a lot of searches. And then the goal is to fish for some more serious crime. They don't really want to charge like a low-level possession crime of marijuana. They're looking for something more. And so I think there's a lot of sort of energy in keeping marijuana illegal at the federal level precisely for that reason.
I think the question also indicates that both states and the justices are cross-pressured in a case like this, because it's probably the case that the states with the most lax marijuana rules also have the strictest gun laws. And the justices who really hate drugs are probably the justices who also really like strong Second Amendment protections. And so these two things interacting, I think, create some questions about this. The justice who most engaged with the marijuana question itself was Justice Gorsuch. And part of what he was questioning the advocates on is, why do we address all these other questions about Robitussin and Ambien? Like, you charged Mr. Hemani with occasionally using marijuana. Can't we just say that his use of marijuana either didn't rise to the statutory level of unlawful user as a habitual user, or that his use just wasn't dangerous enough, and we can leave all these other questions to another day? And he said, like, to the government, why did you bring this case to us when you might even reschedule this into the category that, as Joel said, wouldn't even fall into your backup principle of the narrowest way in which to uphold the statute? And he said, what do we do with the fact that marijuana is kind of illegal and kind of not illegal because so many states have permitted it? And just a lot of the other justices, to my mind, didn't seem as interested in that narrow question about what do we do with marijuana. They seemed to want to say, we are having to announce some kind of broader principle to cover the ordinary cases in which these claims might be brought, or maybe the extremes in which these cases might be brought. And so they were less focused on the marijuana question. But I think as a practical matter, the states are cross-pressured, a lot of advocates and advocacy groups are cross-pressured when it comes to marijuana. And I just want to be clear that my view is that the Second Amendment allows Congress to even make dumb choices. And so do I think that marijuana should be illegal? Do I think that it should be the basis for punishment, including up to 15 years in prison? At least to the latter question, definitely not. I've written on this problem of what I called firearms carceralism, where it's really easy for federal prosecutors to charge these possession crimes. Like Joel said, when they're looking for other things, I don't think it's a good thing. I just think the remedy is not in the Second Amendment.
Well, that's a wonderful segue to predictions of what's going to happen here. And I will especially contextualize this with highlighting that our last two major Second Amendment rulings, Bruin 4 years ago, gave us a whole new Second Amendment test, which is what we're continuing to struggle through, not just on the intersection with drug policy, but with a range of other gun control issues. And then we got Rahimi 2 years later, and Bruin struck down a New York law. Rahimi upheld a different federal prohibition, but with, I think, 8 opinions, and nobody, myself included, quite sure what they added up to. And that was in a context where we were, if I recall correctly, 8-1 in favor of the government. I took away from oral argument that they're going to have a hard time, maybe even getting to 5 on any opinion, which they have to do to some degree. But maybe back in chambers, Joel, your off-ramp will become a lot more appealing as they struggle through their broad positions. I'd love to hear your take on whether you're expecting a narrow ruling that just tries to avoid a bunch of issues, a very broad ruling that tries to take on a bunch of these issues. And I won't make you go so far as to suggest who you think will be writing the opinion for the court, but if you have thoughts on that as well, I'd love to hear them.
My immediate reaction after listening to argument was I think it's leaning towards Hemani is going to win. I had a hard time coming up with 5 justices who would vote in favor of the government. I don't know exactly what the breakdown could be, maybe 6-3, maybe 7-2. What is far less clear to me, and you sort of alluded to this, is what exactly would a majority of the court say? And I have a lot sort of less insight based on argument where exactly their heads are. I'm hopeful, as you said, that maybe sort of a narrow statutory ruling will become more attractive as sort of a way to build a coalition. This might be a situation where we see fractured opinions, right? The court likes to have a majority opinion if possible, but if so, maybe that's very narrow, or maybe it is ultimately a plurality because they can't get 5 to sign on to whatever that is. And then we might see some concurring opinions that are very strong Second Amendment, but then maybe some other concurring opinions that are statutory or something like that. But I guess my only firm prediction is I think Hemani will win one way or the other.
That was my read of oral argument too, which was somewhat surprising to those of us who had been watching the Second Amendment cases coming into it, because the court has 2 Second Amendment cases this term. And the thinking when they first granted cert on these 2 cases was, well, they'll take one case to uphold a law under the Second Amendment. They'll take one case to strike down a law and show, hey, we're handing out wins and losses evenly here. The other case is a Hawaii case that I think most conventional wisdom says the law is going to be struck down. Now, Hemani also, I think, seems like it's going to be a win for the challenger on the Second Amendment claim, or maybe on the narrow statutory ground. But I also have a hard time of coming up with a majority rationale. I counted votes that seem to suggest some willingness to give Congress a role in making categorical judgments, but not a majority that said it had done so in this particular setting. And so if that's right, then you might have a majority for one point, but then different pluralities saying the law is unconstitutional in this setting, some based on maybe their reading of history, but some based on the notion that Congress hadn't made the judgment here. So I would also predict a Hemani loss. I re-listened to the arguments yesterday in anticipation of recording this today, and it's imaginable that there could be some justices who get together for a ruling for the government and the government's favor here on some kind of narrow grounds, but I still think it's most likely that Hemani wins.
When I try to imagine how the government could prevail, it could be a very narrow construction of this and then sending it back down to the lower court for fact-finding of whether Hemani fits into the category that can be prohibited from guns. I also have talked to some folks who have suggested, well, remember the 3 justices, Democratic appointees who tend to be pro-defendant, are also anti-broad Second Amendment law. And so there might be a world in which they want to use this case as, an opportunity to try to rein back on the scope of Second Amendment law. And given that Chief Justice Roberts and Justice Alito at least seemed keen on the possibility of upholding this prosecution, that maybe there are 5 votes to do some interesting Second Amendment work where the drug component of this becomes the vehicle to get a couple of those more anti-gun but pro-government justices along for the ride.
If the Supreme Court sides with Hemani, how is this going to impact state laws?
I'll think of this in terms of my statutory argument. Say I totally get what I want, and they adopt this narrow construction that would basically be the statute itself only applies to those who are possessing a gun while high, basically, right? And you could get there through the Second Amendment, too. The Fifth Circuit got there that way. But say that's the result, then I think that gives a lot of clarity to people in states where, say, marijuana is legalized, right? Because now at least on this question of firearm possession, at the federal level, I'm not going to be prosecuted unless I am possessing a firearm and high, right? Instead of this open question caused by the vagueness of the term unlawful user. When do I qualify as a habitual user? If I used it just once a month, once a week, a couple times a week, it gives some clarity on that question. And so I think from like a notice perspective to individuals, the narrow ruling would be great in sort of bringing the federal system more in line with the state systems.
In terms of what effects it would have, if the court ruled on statutory grounds, that would affect like the 100 prosecutions a year at the federal level. If they say the Second Amendment requires that someone be actively intoxicated to be disarmed, then that affects not just the federal law, but all of the state laws that are similar to the federal law. And so much more far-ranging. The court could also do something like, the government hasn't shown that he's actually a habitual user, and habitual users can be disarmed. It could go all the way up to say, something much higher level of generality that could have an effect not just on the drugs and guns prosecutions, but these federal felon in possession prosecutions as well. And so if it said something like at a high level of generality about the relevant historical principle for laws that disarm categories of people, then potentially that could affect the thousands of federal prosecutions under 922 and the probably tens of thousands of state level prosecutions under similar laws for people in categories of people who possess firearms.
And I'll throw out one more little thing that I think is worth noting. If they were to strike down as unconstitutional this particular provision, I assume it would mean that ATF would have to change its forms when people apply to get a gun, which currently now says verify and swear that you're not any one of these disqualifying things, have a felony record, or otherwise under a domestic violence restraining order, or illegal user or addicted to a controlled substance. And I wonder how many folks, especially in states where marijuana is legal, might worry when they sign that form that they're not telling the truth, because they know if they need a gun, they have to sign that form attesting to not being one of these unqualified folks. And so I think that's where, at least in terms of just people's own relationship to drugs and guns, that could be the biggest kind of real world impact. And of course, we can't go without mentioning Hunter Biden. He famously got convicted under this federal law for cocaine use rather than marijuana use. But one component of what he was prosecuted and convicted for involved lying on the form, where he swore he wasn't an illegal user when it was clear he knew he was regularly using cocaine and wanted the gun and didn't want to admit that on the form because he wouldn't be able to get the gun. And so I think that's where we could see another kind of impact that, again, I think it's particularly interesting to wonder also whether Congress will respond in any way. If this were struck down on statutory grounds, even on constitutional grounds, my guess is the cross-cutting politics that Jake mentioned makes it unlikely that this otherwise inactive Congress gets active in this context.
Maybe I can actually say one more really nerdy thing, which is that the federal form, there's a separate crime of lying on that federal form than being in one of those categories. And some courts have confronted this question of, if you can't constitutionally bar the person in that category, say drug users, from possessing guns, can you still separately charge them for lying on the form? And they've said yes. So if, let's say, ATF didn't change the form and it still asked whether you're an unlawful drug user and you lied on that form, even if this came out for Hemani in this case, and the court said you can't disarm those people consistent with the Second Amendment, conceivably, federal prosecutors could still charge the line on the background check form.
Very interesting. Yep.
That's tricky. Thank you so much for your time, guys.
Thanks again so much, Joel and Jake. I really enjoyed this conversation because it hits me where I am, and I'm so looking forward to both seeing the opinion and hearing your takes on the opinion, and not just here potentially, but across the interwebs where you've been doing great work, keeping us all informed on these issues and others.
Thanks for having us. It was a great discussion.
Yeah, thanks so much, Doug and Hannah.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.